All right, I am going to go ahead and get started. I want to welcome everyone to From the Field, a monthly farm chat with the Idaho Wheat Commission. The goal of these sessions is to cover topics of high interest to growers in a short but complete fashion. And I'd like to thank those of you who are joining us live today and encourage you to put your questions into the chat so that we can address as many of those as possible. And as always, we are recording this discussion and we'll post it to our YouTube and all of our podcast platforms so that others can access it at any time. We do ask that you send us any topics that you would like to see featured in a future episode. And please fill out the survey that you will be sent after the session so that we can continue to improve and make these webinars as useful as possible for our growers. Today, we are thrilled to welcome Jeremy Tamsen, the Director of the Office of Technology Transfer at the University of Idaho, and he is going to discuss the details of the Plant Variety Protection Act, or PVP, and we know there are a lot of questions out there about certified seed and what growers are allowed to save back to plant the following year, and a lot of technical questions. We actually had this requested in a previous session. So Jeremy is the perfect person to address these questions. And Jeremy, thank you so much for joining us, and I will hand it over to you.
All right, thank you so much, Casey. So I'm fortunate enough to call Casey a colleague. Even though she and I work in separate organizations, she and I work very closely together on matters related to Idaho wheat and Idaho wheat research that supports the wheat industry here in Idaho. So I'm the director for the Office of Technology Transfer, and what that means is I help faculty members and graduate students, undergraduate students occasionally, and staff researchers when they have ideas or when they have useful outputs that might be put to work in the marketplace. They work through my office to get those translated. And one of the ways we translate those innovations, those new plant varieties, is by using these seed protections so that we can get them licensed out to growers and to seed producers. So we're going to talk a little bit today. I'm also providing Casey with a handout. It's just a one-page front and back handout that's basically all of the key takeaways from today's presentation. So don't feel like you need to take notes or that you're needing to write this stuff down, because there'll be a little bit of a fallback in the form of this handout that will be provided at the end. So just try to listen in and bring questions either throughout the presentation in the chat box or at the end where I'll stand to address your questions. So thank you so much for attending. So we're going to just get started with a little bit of a history here. So there was a time when seed distribution in the United States was occurring for free, and you were able to get seeds from the US federal government. And so during this early part of the history of the United States, the US Secretary of the Treasury requested that US ambassadors and military officers bring home seed to distribute to US farmers. So they were, in a very early way, they were increasing the pool of germplasm that was being grown in the United States. And they were trying to provide a foundation for what we now know as the industrial agriculture system, but then was much more of a homespun industry, much more of a cottage industry. In 1839, the Patent Office secured funding to collect and distribute seed. So they were not evaluating it necessarily, except that they were doing some quality assessments, but they were not doing plantings, they were not doing trials, they weren't doing anything like that. They were basically just, they got some funding from US Congress to set up a more systemized way to collect and distribute seed. And in 1862, the USDA was established and picked up distribution of seed. And they were doing much more to make sure that the seed was of a quality that was replantable, basically. They still weren't certifying it. They still weren't registering growers. There were a lot of things that today they do, but they at least were established, and they were assigned to distribute seed. And right around the same time, in 1863, the first land-grant university was passed. So that granted 20,000 acres of land to each state per representative, per congressional representative. And some of that land in states that was already really populated was granted in rural places through a certificate system. But that was when the land grant system was passed right around the same time as the USDA was established. So you can see Congress was starting to think really carefully about how food was going to be produced in the United States, and how that was going to make or break our population growth. So Congress grants authority to USDA to purchase and test seeds. So instead of just collecting seeds and redistributing them and doing basic testing for cleanliness and things like that, the USDA was actually given money to go out and buy commercial seed and test it and start to conduct the type of testing that we think of today. In 1924, the USDA seed program was terminated. And in 1939, the Federal Seed Act was passed into law requiring truth in labeling. So the Federal Seed Act this early Federal Seed Act really was just a truth in labeling act. It was, it gave penalties to people who sold varieties under a name that was well known or that was commercially valuable. And if they could prove that that was not actually that variety, but it was still, the registration of seed was still in its very infancy. And so those varieties were not really that well known, were not really that hardened off, were not really that commercially valuable in terms of being able to trade them for a cost. So you can see too, there's a little sidebar here, although there was some limited protection through hybridization because companies could protect the ability to reproduce the seed. They could keep the plants from being reproducible, the seed from being replantable. Companies wanted more protection for their R&D efforts if they were going to be in charge of developing and producing and selling seed after the USDA seed program was terminated. So they, the free seed distribution was seen by the companies as a barrier to them continuing to improve seed through continued investment because they were unable to leverage it commercially after they were finished. So this is a little bit of a background context. So in 1970, it took a long time, right, for the US Congress to figure out what they wanted to do here. But in 1970, the Plant Variety Protection Act was passed. And so this provides intellectual property rights to breeders of new plants, which are sexually reproduced, so by seed. Breeder must demonstrate the variety is new, distinct, uniform, and stable, and a deposit of the seed must be made. So this is done with the PVP office. Protection based on phenotype and not process. So that means that it's based on what the plant actually looks like, that the plant, when you plant it in the ground and when you grow it up yourself, that plant must be new, distinct, uniform, and stable. It doesn't matter necessarily how you've come about the stability or that stable plant variety, but so much as that it's a stable plant variety that meets the criteria. So any embedded intellectual property must also produce an observed phenotype. So for example, you might have an embedded gene that allows it to be herbicide resistant. The Clearfield technology is an example of this. And so the phenotype shows up in that the wheat survives application of any herbicides. And so you've got to have that. You have to have an observable phenotype to get that protection inside the PVP protected variety. So when it was first enacted, PVP protection lasted 18 years. In 1904, it was extended to 20 years after the certificate issues. So now this more closely matches the protection that you can get with a plant patent, which is what they were trying to do at that time. They were trying to align those two a little bit more closely together. So you see the sidebar has your takeaway. PVP certificates protect the right to manage the use of protected varieties by other breeders, to exclude others from marketing and selling protected varieties, and to enjoy legal protection for investments, specifically in seed development. Okay. And so at the time that you make the PVP filing, this is the big point. At the time that the PVP filing is made, this choice is made by the applicant. So the applicant either allows the sale of uncertified seed, or the applicant limits sales to only a class of certified seed, either registered or certified seed. So this is one of the points where restriction can come into play, is when the applicant files the PVP application itself, and at that time they make this choice. So under the first choice, certificate holders must resort to civil action if their rights are infringed upon within the period of PVP protection. Under option 2, sale of uncertified seed by the variety name are in violation of both the certificate owner's rights and federal and state seed laws. So if the applicant, the PVP applicant, the variety owner says, hey, I only want certified seed sales of this variety, you not only get smacked by that producer, by the variety owner, but you also get smacked by the feds and potentially even state laws. There are criminal penalties for this, which was part of this. So just be aware, this will be one of the terms that's included in your license. If you've got a PVP variety that's growing, it will indicate whether you can sell uncertified seed or whether sales must be limited to a class of certified seed. So this is the Title V restriction. It's number 2 there. Okay, in Plant Patent Act of 1930, plants may qualify as a patentable invention. So plant patents were first meant for asexually propagated plants. So plants that were capable of sexual production are not excluded from consideration now if they have also been asexually reproduced. So that was a change. Originally, there was no exception for that, and it was only asexually propagated. So enacting the Plant Patent Act, Congress explained at length its belief in the work that the plant breeder is aiding nature, and that is the patentable invention. And they relaxed the 112 requirement. So this is the description requirement for how the plant came about. This is one of the requirements of a plant patent filing. You must, if in a regular patent, you have to describe, for example, how you came about an invention or how you came about a new discovery and put it to use. And the US Congress realized that it was very difficult for breeders to explain beyond a certain point how a plant came to be, right? They know only up to a certain point how a plant was domesticated and how it was developed. And so the federal law was relaxed to allow the description to be as complete as reasonably possible, rather than to be absolutely complete, as is typically the requirement with a patent. So this is similar in that it protects the right to exclude others from asexually reproducing the plant, though, and from using, offering for sale, or selling the plant so reproduced or any of its parts throughout the US, or from importing the plant into the US. And so this lasts 20 years from the date of filing the application, which is a little different. The PVP lasts 20 years from the issuance of the certificate. So you get a little bit more time potentially on a PVP cert. Okay. And so this is just kind of an interesting trend. So we have plant patents being pretty consistent. Sorry, this number is a little bit dated, but the numbers are a little bit harder to come by. Patents versus PVPs, because it takes a little bit longer for them to work their way through the system. So pretty consistent plant patent filings, around 18,000 issued by September of 2018. And you can see some leaders there. And that probably doesn't surprise anybody on the call to see that we've got these large companies making moves in the plant patent area. So PVP applications on the converse are in a downward trajectory. Large companies are increasingly focusing on developing stable traits to breed into varieties, and they are investing fewer resources in new variety development. What does this signal for the future? I mean, I don't know. You guys tell me. Kind of interesting to see this, but it may signal that that we're going to have fewer varieties coming out over the next 5 and 10 years, and then see kind of an increase in the number of traits that are coming out, and then maybe an increase in the need for plant variety development. So we'll see kind of an interesting pairing of trends there on the horizon. So one thing that may be leading to some of these these trends is changes in exemptions. This is one argument. So exemptions may play a part in the shrinking PVP applications. So in 1970, the PVPA had an exemption built in for farmers wanting to save seed from a protected variety. And prior to 1994, farmers could save seed, and they were able to sell that saved seed to other farmers. But in 1994, the farmer-to-farmer seed sale exemption was eliminated. And so this happened in two ways. The US Supreme Court in Asgrow Seed versus Winterboro, the US Supreme Court allowed that the farmer could only save back enough to plant his or her own fields and not enough to sell to other farmers. And that if the farmer did make a sale, that sale was going to be illegal. And at the same time, the US Congress passed a new law that made it explicit that growers of PVP protected seed can no longer conduct such brown bag sales, so that the US citizens didn't have to only rely on the US Supreme Court decision, but that the US Congress acted as well in the same year to ban those seed sales. Protection of potato and other tuber crops were also added in 1994 to offer PVP certificates as an alternative to plant patents, because as I mentioned originally, PVP certificates were only for plants that were sexually propagated. And of course, we know that botanical seed from the potato does not grow true, and so they had to issue an exemption to allow tuber crops to also qualify for PVP protection. So these amendments, critically, they allowed the US to join the UPOV, which is an international plant breeders' rights treaty. And this allowed US-based breeders to access more germplasm from around the world by trading more freely with other breeders. And there continues to be a research exemption, however, in the Plant Variety Protection Act for protected varieties for anyone engaged in research and or developing new varieties. Recognizing that this takes between 7 and 10 years potentially to develop a new variety without any enhanced genetic techniques. And so the PVP Act does continue to allow a research exemption so that growers of PVP protected varieties can still conduct research. Now beware, that may be against the license that you have with the variety owner, but the federal law itself does not prohibit you from that research activity. So as I said, I'm going to give Casey this handout, and this just has a little, it's hard to see that, a few notes on here, front and back, for you guys to keep in mind. And critically, it has the point of when it is illegal to replant and resell seed. And so I'll provide that for you guys for quick reference. But I also want to just mention that we're here at the university to provide a service to the whole state. We, of course, are the university's land grant, or the state's land grant university, and we're a huge contributor to the state's wheat economy. And so I want you guys to feel free to use us as a resource if you have questions related to this topic. You can feel free to reach out. That's the departmental email address there. So myself or somebody like me will get back to you with a response if you have a specific question that doesn't get answered today. And that's all the slides that I've prepared. So I'm going to stop my screen share so that we can see each other now if folks have questions that they would like to raise.
That's a great overview, Jeremy. Thank you so much. And I do hope that people will put their questions in the box. I see that we have one already. Under what circumstances would a researcher decide to patent a plant invention rather than seek out a PVP?
That's a good question. Typically here at the university, we use PVP protection when we have a new variety that we want to license or that one of our sponsors wants to license. The plant patent really comes into play when you have something that's difficult to reproduce sexually. For example, it can be difficult to do that. So that was the original reason for the differentiation. Today, it's not so different. And large companies, if they have a variety that they believe will be very successful, you will often see that they have a plant patent as well as a plant variety protection certificate. The protections are slightly different and the requirements on the owner are slightly different as well. Some of that is detailed in the handout. So for example, if you have a plant patent, you have to pursue infringers throughout the entire period of plant patent protection. Whereas with the PVP, you're only responsible for 6 years following or 6 years prior to the filing of the PVP application. So it could be a difference in enforcement posture. And then it also could be a difference in embedded intellectual property. So if a plant variety has a trait that could be bred into other varieties, and usually this trait is developed through mutagenic seed techniques. So bombarding a seed with radiation, bombarding it with chemicals, bombarding it with other adverse environmental conditions, and causing it to have a spot mutation that you can leverage successfully into other varieties. Typically, that's where you'll see plant patents the most, is where you have a trait that you want to protect. But it just depends on the specific circumstance, what exactly the plant is, what exactly the trait is, and what you intend to do with it into the future. That's a very good question.
Great. Okay, I have another one here. Could you define a little bit what public release is? I think we use that term maybe loosely and not always correctly. And if you could just kind of cover that.
Yeah, sure. And so there are a couple of different ways that people use that term. Historically, universities and other public breeding programs would release seeds without any plant-back restrictions, without any Title V protections, without PVP protection in most instances, and certainly without plant patent protection. That was truly a public release. And so what was charged to the producer who was coming to pick up seed was just the cost for producing that seed in the ground and harvesting it and cleaning it in that. There was no additional fee attached to it. And now funding for plant variety development has changed dramatically over the last 100 years. And part of that funding stream, part of it is the recognition that that funding stream needs to be protected now. And so that's part of the reason why we have these protected releases, so that we can continue to justify investment in crop improvement as time goes on. But that was really the traditional public release. There is sort of a hybrid or a camel royalty-free release now, like we've done with UI Cookie, is a great example where that wasn't, we still PVP protected the variety. We still want to have good control over the quality of the variety and over that name brand that the variety carries, to ensure that farmers are getting exactly what they believe they're getting. But we don't charge any royalty back for that variety, and it doesn't have any of those clear field genes or any other genes in it that require us to pay a third-party trait fee. And so although we don't today have a lot of public releases like maybe at one time we did, we still are looking at innovative ways of getting germplasm into the hands of producers in a way that's affordable. So that's kind of the history and the modern version of an open release or a public release today.
Great. So from your slides and your discussion here, it sounds like there is no brown bagging or farmer to farmer sales allowed under any PVP variety. And so one question is, how many varieties are released these days without that PVP protection? And then also, where could growers go to see what restrictions are on a variety that they are using?
Yeah, those are both good questions. So, that's a very good question. Where would you go to get a public release today? I'm not sure. I'm not sure that people are still scaling those releases. There might be some small seed dealers where you can get that type of a release. But buyer beware, right? This was the Federal Seed Act of 1930. Was buyer beware. We want truth in labeling. We want buyers to know what they're buying. It's difficult to know what you're buying when you go back that far to purchase seed from a variety that was released publicly, maybe many decades ago now. So, again, buyer beware when it comes to that kind of stuff. You may be able to find it, but I would be pretty wary about putting something like that into my ground. And sorry, the second part of the question.
Where can a grower go to see which restrictions are placed on each variety?
Right. And so when you purchase seed from the seed dealer, they're gonna want you to fill out a license, and sometimes they're also gonna want you to fill out a stewardship agreement or something that is similar. It might be a material transfer agreement or a plant use agreement or a testing and development agreement or some mix of those words. But they're going to have some agreements for you to sign when you pick up those protected seed varieties. It's going to be in those agreements. So as always, read everything carefully that's presented to you before you sign anything, especially if your business depends on it. And then stick to those restrictions. They're not meant to hurt farmers. In fact, the opposite is true. It's meant to keep seed pure. It's meant to keep your ability to buy seed from dealers. It's meant to support the industry overall, even though it is a cost. So there's a cost to that protection, there's a cost to that support, but there is value in that you know you're getting something valuable when you go to purchase those varieties. So.
Great, thank you. So I think, we've touched on a really interesting point when you said that there's a lot of focus these days on trait development and not necessarily as much on variety development, and that may continue to be even a bigger gap here in the future, which I would just make a plug for the importance of the public breeding programs, because those are programs that growers really can help kind of focus on varieties and things that are going to work in their fields, which is great. But maybe if you could touch on how many varieties are developed, how many are never even really come to market, and why do some get licensed and some don't?
Yeah, that's a great question. You guys, we have a lot of germplasm. I mean, I really mean that. Let me say it again, actually. We have a lot of different plants, and you can look through any of our variety trials and see the numbered lines, and if they start with ID dash blah, 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 that's going to be a University of Idaho plant line. And there are lots of them that go into variety trials every year. And there are lots of them that fall out of the variety trials year over year. And so really what we're doing is we're looking for the best of the best of the best. And that goes in a lot of different directions based on what the checkoff dollars are funding and what other grant dollars like the USDA, what their programs are going after to fund. But primarily that direction comes from the checkoff dollars, from the research that's conducted with the Idaho Wheat Commission. And it's really varied. Sometimes we're breeding for pathogen resistance. Sometimes we're breeding for really high harvest yield. Sometimes we're just trying to get a new trait introgressed into our lines from somebody else, like BASF, for example. So it really depends, but it's a long process, and it's still a very, very manual process. We involve dozens of student workers every year in the fields to do these field trials, to do these strip trials, and to make sure that everything goes according to plan, so that that data is reliable, basically, in each area of the state. How many varieties don't get released? I mean, it's a lot. There's a substantial amount of work that goes into plant lines that never, like we'll say they never go anywhere. They just go to the field and they come back and that's it, and they don't even get maybe scaled up at all, or they don't exhibit the trait that we tried to breed into them, maybe, or they don't have the pathogen resistance that we hoped for, or they don't have that high harvest yield that we were trying to go for. So it just depends. It's research is a trial and error process, and it takes a long, long time when you have an organism that takes several months to develop into an observable phenotype. So yeah, it does. There's a lot that goes into it. There's a lot that falls out of it. And we try to keep, like I said, just the very best of the best to scale up and protect and sell out to the seed producers.
That's great. Well, I do not see any more questions in the chat, and we have hit our half an hour. So I am going to just thank you, Jeremy, for your time today and all of this great information. We are going to post not only the recording, but obviously also the takeaway sheets on our website, and really just hope that if anybody has additional questions, they can contact us or Jeremy, and we will get those answered. So thank you, Jeremy, and thank you to everyone who participated and your great questions.
Great. Thanks a lot, Casey. As always, great to see you, and thanks to everybody who joined us. Again, feel free to reach out if you guys have questions that crop up after the conclusion of today's session, and I look forward to working with all of you in the future.
Thank you. Bye, everyone.
Bye-bye.